Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series, and this Curious Lawyer program is on travel law and the right to travel. We are going to today explore everything related to everything you've ever wanted to know about traveling domestically and abroad, and what is the right to travel. Before we get going though, I want to tell you a little bit about our Curious Lawyer series and some of the other programs you can look at, because this is a different way to do CLE. This is a way to be educated and entertained, I hope, at the same time, and learn about a very different area of the law in all likelihood to anything you practice. But it's incredibly valuable because it lets you get the opportunity to experience different areas of law, how they intersect with different issues in our society, which broadens your understanding about the laws and the legal regimes that we all confront as a lawyer, unless you even find analogies I've found to bring into your practice area. And so as a result, as you see on our slide here for our Curious Lawyer series, we have looked at dog law, where we look at how our favorite furry friends intersect with all areas of legal regimes, trusts and estates, contracts, tort law. You get your education, but you get to learn about how the dogs, how they fit within our legal regime. We've done it for many areas. CIA law. You want to know the famous saying, I can neither confirm nor deny? Where did it come from? Watch CIA law, you'll find out. Turns out it came from a lawyer. We've even looked at whether in the Yellowstone National Park, there's a little sliver of the park that's crime-free, where you can do whatever you want. You can murder someone and get away with it. Can you not? Watch the program. Exploring copyright law through the music of U2. We've looked at a program on crazy, weird laws. And a new series, the Bill of Rights series, we've taken each of the first 10 amendments to the Constitution and spent 1 hour on each of them to really do a deep dive into each of them so that you can be at the next cocktail party and be an expert on all of them. So that's our Curious Lawyer series that lets you, the curious lawyer, stay curious. But today, what's our itinerary on our next slide for our travel program today? Well, our travel itinerary is as follows. We're looking at the right to travel domestically and abroad, and we're going to look at the constitutional mooring of this. Where does this come from, this idea that there's a right to travel? We've all said it, we all understand it, but is it written in the Constitution expressly? And if not, where do we get it from? Which raises, on our next stop of our journey here, the issue of what happens in emergencies. We're going to look at Cold War limits that came about on the right to travel. Do you have a right to go to Cuba? We will see cases that went all the way up to the U.S. Supreme Court litigating these issues on the metes and bounds of this right to travel. We're also going to look at passport rules and the fascinating little subworld of passports, the rules that revolve around some passport issues and some litigation that's occurred in that zone. And we'll move on our next destination as we do our little travel journey today to airport warrantless search rules in the Constitution. And how is it that when you go to the airport, they just get to look in your bag at will and pat you down at will without even suspecting you of doing anything? Not like on the street, but we're going to look at why that is. And of course, as we continue our journey, we're going to look at embassies and international law. Is an embassy U.S. soil? Are you on America when you're in that American embassy in Casablanca? Is it a safe zone? What kind of a safe zone? We're going to answer all those questions for you today, and we'll wrap up, of course, with our conclusions. So sit back, grab a cocktail if you want, and get ready to go on a little travel journey here before you do your real traveling. We'll start on our next slide looking at the historical basis. Where does this come from, this right to travel? Well, interestingly, it goes all the way back to the Magna Carta. The Magna Carta discussed travel rights as being part of one's personal liberty. And this was then later described by Blackstone in his treatises in the 1700s and his commentaries as following. This personal liberty consists in the power of locomotion, of changing situation, or removing one's person to whatsoever place one's own inclination may direct, unless by due course of law. It is a right strictly natural. So that's from Blackstone's commentaries at 130 in the year 1765, where he is articulating this idea that went back to the Magna Carta as being one's personal liberty consists of the right to control your body and transplant it and move it to wherever you want. In 1770, you see here, Thomas Jefferson spoke also about this idea that undergirds the right to travel. Here's his quote. "Under the law of nature, all men are born free. Everyone comes into the world with a right to his own person, which includes the liberty of moving and using it as his own will. This is what is called a personal liberty." And then in the Articles of Confederation in 1777, we actually have the closest textual tie to a right to travel in the founding documents, where it literally says, "And the people of each state shall have free ingress and regress to and from any other state." That obviously necessarily means a right to travel across the borders of states. Now, we're going to continue with this historical basis by unraveling it a little bit more. And on our next slide, as you see here, we're talking now about the basis for the right to travel. So let's get into our Constitution a little bit more and some of the Supreme Court cases that have spoken about this. If we look at the Constitution in Article 4, it provides that citizens of one state in another state are entitled to all the privileges and immunities of a citizen of the latter state. Now, this is the closest textual basis in our Constitution to the idea of a right to travel within the nation. Similar to the idea we saw in the Articles of Confederation, but it really necessarily gets that there must be a right to travel. And so what we see then is in one of the earliest Supreme Court cases ever to confront the issue of the right to travel, so to speak, we see it in 1869, and this is the case of Paul versus Virginia. It's reported at 75 U.S. 168 in 1869. And here's the quote from our post-Civil War Supreme Court. "Without some provision removing from citizens of each state the disabilities of alienage in other states and giving them equality of privilege with citizens of those states, the Republic would have constituted little more than a league of states. It would not have constituted the union which now exists. It gives them the right of free ingress into other states and egress from them." So if you just pause there for a second and ponder the significance of that, what's so critical to our whole systemic nature of our government, the federalism system with our different states, is that we have free ingress and egress between them. And we only really exist as a real republic of our nature because of that right. Because otherwise you'd just be like, Europe before the EU, right? Just a bunch of states next to each other that you need the right to go in and out of. So it's this fundamental right of travel that even if it's not talked about in the Bill of Rights as, freedom of speech, freedom of travel, even if it's not articulated in that way, it's so sort of ingrained and organic to our system and to this idea of Article 4, rights and immunities to go back and forth, that it must be a fundamental right. And so, as we continue moving along, it's been moored also in the 5th and 14th Amendment. Fundamentally, it's just simply part of due process. And here's what the Supreme Court has said in 1999, and we'll talk about this case in a little while in more detail, but this is a case of Saines versus Roe at 526 U.S. 489, and this is what they said at page 498. "The word travel is not found in the text of the Constitution. Yet the constitutional right to travel from one state to another is firmly embedded in our jurisprudence." And we see in another case, this is coming from the 1960s, of a Justice Stewart concurring opinion. "The right is so important that it is assertable against private interference as well as government action, a virtually unconditional personal right guaranteed by the Constitution to us all." That's what Saines versus Roe in 1999 said, and where it got there is it was citing to that Justice Stewart concurring opinion from the 1960s. So in citing a 60s concurrence opinion, it really did enshrine the idea that it's beyond critical and it's a virtual unconditional personal right guaranteed by the Constitution to everyone. Let's move along now to the Supreme Court, SCOTUS and the right to travel. And the first case we're going to look at today is from 1941, and this is the case of Edwards versus California. It's reported at 314 U.S. 160, and this is a case that involved the following fact pattern. We were in the Great Depression, and at the time California passed a law, and California law made it as a result a crime to assist paupers entering California, people who were destitute without money. And this was known at the time as the Okie Law. So it was known as the Okie Law because lots of people were leaving the Great Depression, the Dust Bowl, all the huge problems that obviously affected the Panhandle area. And so it's known in the jurisprudence as what was at the time called the Okie Law. So this Californian named Mr. Edwards, he drives to Texas and he returns with his indigent brother-in-law and brings him back to California. Edwards gets arrested and convicted, and he gets a 6-month suspended sentence. And he's convicted of this idea that he assisted his indigent brother-in-law coming into California, and so violates California state criminal law. And this was California Penal Code 2615 at the time. So here's what the Supreme Court held. The issue presented in this case, therefore, is whether the prohibition embodied in Section 2615 against the bringing or transportation of indigent persons into California is within the police power of the state. We think that it is not, and hold that it is an unconstitutional barrier to interstate commerce. The grave and perplexing social and economic dislocation which the statute reflects is a matter of common knowledge and concern. We are not unmindful of it. We appreciate that the spectacle of large segments of our population constantly on the move has given rise to urgent demands upon the ingenuity of government. But this does not mean that there are no boundaries to the permissible area of state legislative activity. There are, and none is more certain than the prohibition against attempts on the part of any single state to isolate itself from difficulties common to all of them by restraining the transportation of persons and property across its borders. And so what's core here is the court held that you may be struggling and bothered by the fact that you have lots of indigent people coming into the state, draining the system, causing crime, whatever the police power of the state believed it had to justify that law. It doesn't matter, because what the law is doing is tripping this fundamental right to travel. People have the right to come in and out of the state regardless of financial status and means and wealth. And you don't get to, even in a legitimate exercise of police power that is based on rational activity and rational basis, fact-finding and all that, you still don't get to do it because this fundamental right of people to come in and out of the country, the states, to travel, is being infringed. So that's one of the Supreme Court's earliest forays into the right to travel in 1941. And we're going to shift from 1941, we're going to fast forward a little bit to the 1960s. And we're next going to go to 1966, as you see here on our next slide. And this is, again, SCOTUS and the right to travel. This time we're going to look at the case of United States versus Guest. It's reported at 383 U.S. 745, and it was decided in 1966. Here are the facts of U.S. versus Guest, then. People were indicted by the United States government on a conspiracy, and these were state officials, and this is coming out of the 1960s civil rights situation. Anyway, they're indicted for a conspiracy to deny Black Americans their constitutional right to use state facilities and to freely travel. And so the underlying facts don't particularly matter, other than the fact that they were engaged in this behavior that was denying people those abilities to engage in those, basic sort of human rights behaviors, traveling, using state facilities and the like. And even they get indicted for it under federal, these criminal-based civil rights statutes. And the trial court, the district court, dismissed the indictment. And the district court dismissed the indictment because it held that these rights at issue were not really attributes of national citizenship to which the criminal statute depended for its viability. And so therefore, even if a whole bunch of people engaged in sort of behavior that denied people access to state facilities or that denied them the ability to freely travel, the court basically said it's not a federal criminal statutory problem because the federal criminal statutes only allow, prosecutions like this if national citizenship type rights are being infringed. And it concluded these were not. So let's listen to Solicitor General Thurgood Marshall. This is right before he was put onto the U.S. Supreme Court. Let's listen to him arguing the case for the right to travel actually being rooted in the Constitution such that these statutes were lawfully applied to the defendants. Let's listen.
Let me put it this way. These rights guaranteed, whatever they may encompass, by the 14th Amendment. Are you suggesting that they come in the category like the right to travel under Crandall and Nevada, protected by not the 14th Amendment, but Section 2 of Article 4, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states?
No, sir.
You're not arguing.
I'm arguing the 14th Amendment.
All right. And you're arguing, but you are arguing paragraph 3, aren't you, on Crandall? Or
Yes,
4,
sir.
rather.
4. It's
Crandall
on
and
4.
Nevada.
On 4. That's Crandall and
Well,
Nevada.
am I wrong? I haven't read it in some time. But
We
didn't that rest on Article 4, Section 2?
Specifically went to the Commerce Act, as I remember. It was very general.
Oh, on the Commerce Clause.
Yes, sir. Power under the Commerce Clause. But it's our position that the 14th Amendment...
Well, am I wrong? I thought Crandall had also dealt with this right of travel
It
in
was
that
travel.
context. That was a tax, wasn't it, against passengers on a train or
That's
something?
right.
I thought that...
That's right. That's right.
Didn't that implicate Article 4, Section 2?
We got it right here. 50...
Well, don't waste your time on it. I hope. But in any event, whether it did or not, you're not making that argument as regards these general rights secured by the 14th Amendment. Is that it?
No, sir. We take the position, well, to put it another way, we take the position that the 14th Amendment rights are just as important as any of the others. But that when you realize that this particular congressional act was passed pursuant to Section 5 of the 14th, obviously they meant to protect 14th rights.
Well,
but they also protected the others.
Well, what got me off the track was I think you said something about privileges and immunities.
I was talking about the 14th Amendment privileges and immunities.
So there you heard Solicitor General Marshall arguing for how this is rooted in the Constitution. This is what the Supreme Court then held after that oral argument. The fourth numbered paragraph of the indictment alleged that the defendants conspired to injure, oppress, threaten, and intimidate Negro citizens of the United States in the free exercise and enjoyment of the right to travel freely to and from the state of Georgia and to use highway facilities and other instrumentalities of interstate commerce within the state of Georgia. The district court was in error in dismissing the indictment as to this paragraph. The constitutional right to travel from one state to another and necessarily to use the highways and other instrumentalities of interstate commerce in doing so occupies a position fundamental to the concept of our federal union. It is a right that has been firmly established and repeatedly recognized. That's at page 757. And so here you see the U.S. Supreme Court ultimately saying, no, a criminal prosecution can go. Those statutes are legitimate because they were based upon this fundamental constitutional right to travel, which means if it's abridged, they can be criminally prosecuted there. So the statutes were actually focused on lawful attributes of national citizenship because the right to travel is rooted in the Constitution. So Guest was a very important case in the 1960s dealing with the right to travel. And so we've gone from the 1940s to the 1960s, skipping a generation, and we're going to skip forward about another generation to the 1980s. And here you see on the next slide, we're asking the question, is there a right to travel anonymously? And what does that mean exactly, and what are the contours of that? Well, this was partially answered for us in the case of Colender versus Lawson. It's reported at 461 U.S. 352, and it's from 1983. And so here are the basic facts of this case that went up to the U.S. Supreme Court. California has a penal code, or had a penal code, statute 647, was section 647 at the time. And section 647 required people who loiter around in public that if a police officer came into contact with them, they had to provide, quote, credible and reliable, end quote, identification with a reasonable means for the police to later get in touch with them. In other words, some sort of identification with an address or something such that if the police want to follow up later, they can track you down and find you. So, Mr. Colender is a black American and he had long dreadlocks and he was wandering around in a white neighborhood. And this apparently happened repeatedly and he was stopped repeatedly. And at some point, identification was demanded of him. Unhappy with this, feeling this is unconstitutional, this issue then gets litigated. And the case goes up to the U.S. Supreme Court, and the U.S. Supreme Court holds that this law, this California statute, was unconstitutionally vague, in part because of this credible and reliable language, because such kind of, frankly, vague, language gives unfettered authority to the police to stop people and impinge upon their right to movement or travel. And so it was the idea that this void for vagueness doctrine was employed, wasn't just employed in a vacuum. It was employed because enforcing the statute actually damaged people's free right to move, travel. And so here's the quote. In addition, Section 647E implicates consideration of the constitutional right to freedom of movement. And so what this case then answers, really fundamentally at root, is that we actually do have a right to travel about our business, what we're doing, running around, walking walking your dog, going to the beach, whatever. We have the right to travel, as we all know, but we also have the right to do so anonymously. And the police don't just have the right to come over and say, give me your identification, please, and I want to be able to know who you are and where you are. That would actually be an impingement upon, our right to travel anonymously. Now, the case, of course, pivots on this statute about giving identification with the ability to be tracked down later. It could be limited to those facts, but at a broad level, it really does stand for the Supreme Court weighing in on the importance of our right to move freely about our society that we all live in. And so that brings us to 1983. Now let's go forward almost another generation to basically the eve of the 21st century. We're going to party like it's 1999, and this is the case we talked about earlier of Saines versus Roe. It's reported at 526 U.S. 489, decided in 1999, and here are the facts of this case. We have a California law that denied welfare benefits to newly arrived residents. And this was then challenged as unconstitutional as an impingement of someone's right to travel freely within our states and reside in California. And it was basically argued to the Supreme Court that this is impinging on the right to travel. And so you can see that already now, even, we looked at the case generations earlier, from 1941, in World War II, where California was frustrated at people coming in who were impoverished and tried to criminalize that. Now we have another kind of similar approach where this time it's denying welfare benefits to new people. And so let's listen here to Mark Rosenbaum, the famed Supreme Court advocate, famed ACLU lawyer, teaches at University of California, Irvine also. Here he is arguing the fundamental basis in the Constitution for this right to travel to the Supreme Court.
That if a state acts to implement the authorization under 604C, that implementation ought to be tested under a level of scrutiny in which it should be upheld if the state can show that it has reasonably tailored its implementation to the important federal purposes of the federal statute.
How has California tailored it at all? If people have moved to California for reasons that have nothing to do with welfare.
That's exactly, and
relatives living there or health reasons or whatever, and having moved there want welfare benefits. How have they tailored it?
In our brief, Justice O'Connor, we have suggested that it appears to us that California has not, in fact, tailored it, and therefore the court ought to affirm the preliminary injunction. If you look at what other states have done, Illinois, for example, has one of these residency requirements or two-tier systems, but it won't apply unless the new resident was obtaining welfare benefits from the prior state. You could also tailor it by saying that it won't apply to people who come to the state, as at least one of these plaintiffs did, for a job and then lose it, because those kinds of people, it's clear Congress wanted to encourage people to move in order to obtain work.
It's not in the congressional authorization. The congressional authorization just says gives permission to states for the 1 year. Isn't that right?
May I answer?
Yes.
The congressional authorization simply sets the outer bounds of what Congress will permit a state to do, but it does not give them a free pass through the constitutional test.
Thank you, General Waxman. Mr. Rosenbaum, we'll hear from you. Mr. Chief Justice, and may it please the Court, the California durational residency requirement is antithetical to core structural and liberty-producing values of our federal system of joint sovereigns. As Justice Ginsburg's comment indicated, the genius of our federal system is that citizens are free to vote with their feet. They are free to migrate to and settle in whatever state they choose, based on whatever needs or tastes they have.
They're free to travel. I assume travel includes I have just as much a right to go to another state temporarily and enjoy the protections of that state temporarily as I do to go and migrate there.
That's correct, Your Honor.
And yet, when I go to another state, am I entitled, and I'm there just temporarily, am I entitled to send my children to the state schools?
Well, that would be an Article IV question, Your Honor, but that's not
Why isn't the right to travel affected? Or when I go there, am I treated like other citizens of the states for purposes of hunting and fishing, for example? Don't I have to pay an out-of-state fishing and hunting license fee?
Your Honor is referring to a non-resident, is that right?
A non-resident, but exercising his constitutional right to travel.
The answer, Justice Scalia, was most recently stated in this Court's opinion at Bray at page 277, and that is we are at a point in the jurisprudence that the right of free interstate migration includes not only protection against the erection of actual barriers, but it means that interstate travelers are treated no differently than intrastate travelers. It's the same point that
I don't understand. You try it again.
The problem with this...
It seems to me my right to travel is certainly being affected, but it seems to me not significantly, and it seems to me that what's involved is a state benefit, and therefore we say it's okay.
No, I don't agree with that, Your Honor.
All right.
For this
tell
reason.
me why it's different then.
Because the second part of the equation with respect to the liberty-producing values that we're talking about is that once an individual chooses to move to a state for whatever reason she chooses, establishes bona fide residence, the Constitution creates a relationship between the citizen and the state.
But there is a difference between a bona fide resident, someone who's there to stay, and a temporary visitor.
It certainly is, as Justice Scalia pointed out.
Not so far as the right to travel is concerned. I thought it's the right to travel, not the equal protection clause that we're dealing with here. I agree that once you're a citizen of the state, you have to be treated like other citizens unless there's a rational basis for treating you differently. But you're not arguing before us the equal protection rational basis test. You're arguing that somehow the right to travel entitles you to something more than a rational basis in how you're treated.
Your Honor,
and I don't see why that doesn't apply to the situation when I'm traveling without desiring to establish permanent residence, just as it applies when I'm traveling to establish permanent.
It may well be, Your Honor, that an individual who is not a bona fide...
I'm glad to learn that, because I would like to be able to get Louisiana hunting licenses at Louisiana resident rates.
Your Honor, we're in the circumstances that you're describing, where we're not dealing with a bona fide resident. Sure, the state can make all sorts of distinctions. This Court said so in Martinez v. Bynum. The problem
but why? The question is why? If the right to travel is what you're urging here, not the equal protection clause, why should that be?
Because the right of interstate migration, the right of free interstate migration, has two components, not just against actual barriers themselves, but when an individual establishes bona fide residence, that individual becomes the state's own. And
you're just restating it. You're not giving me a reason for it.
The
one, just like the other, involves the constitutional right to travel.
No, Your Honor. The right to travel that we're talking about is a right not to be discriminated against based upon the length of residence. Why is that? Because if a state could discriminate based upon the length of residence for a bona fide residence, then it would radically revise the federal system. It would mean
where do you locate that right? In the Privileges and Immunities Clause, or where?
I'm sorry.
Where do you locate the so-called right to travel? Is it found in the Privileges and Immunities Clause or someplace else?
Your Honor, there are four sources in addition to the logic and structure of the constitutional scheme itself. First, as Your Honor stated, and as Your Honor specifically described in the Zobel concurrence and in Your Honor's dissent in Soto-Lopez, Article 4, Section 2. In addition, the 14th Amendment, through the Citizenship Clause, the Privileges or Immunities Clause, and the Equal Protection Clause, those four provisions of the Constitution create a principle. The principle is that a state may not negate a national citizen's right of choice of state of residence by classifying newcomers so as to deny them the same rights.
What do you do with the tuition cases?
The tuition cases are just as Justice Scalia indicated, Your Honor. The issue in the tuition cases, like the Starnes case, as this Court explained in the Zobel case and in Volandis, the issue there was the individual in fact a bona fide resident? Of course a state may preserve its state resources for state citizens.
But in Dunn versus Bloomstein, where we're talking about a waiting period for voting, the Court said you can't require a one-year waiting period. So why in the tuition cases were they allowed to employ a one-year waiting period?
Let me answer that in two ways, Your Honor. First, in the school tuition cases themselves, as the Court indicated in Volandis at pages 253 and 254, the concern was with a population that was characteristically transient, as Justice Ginsburg said, coming in to take the benefit and run. A concern that, in fact, we have a permanent attachment, a genuine attachment. In Dunn, while the Court said, sure.
Let's pursue that. The concern was that someone was coming into the state to go to the college there for only 1 year?
No, Your Honor.
Transfer out to another college?
No, the concern was...
And what good does the one-year residency assure? What good does that do?
Because
if it simply requires the college freshman to stay there until he's a sophomore?
Perhaps I'm not communicating clearly, Your Honor. The problem in Starnes and the school tuition cases is that a state has a compelling interest, has an absolutely appropriate right to say, before we give some of our basic resources that we would otherwise reserve to our state citizens, we want to make sure that this individual is in fact a bona fide resident, has some sort of permanent attachment. That's why and with students, peculiarly a characteristically transient population, there was reason to be suspicious of the motives of the individuals that are coming in. Compare that to this case. As the State has conceded as recently as pages 17 and 18 of its reply brief, there's no question that we're dealing with bona fide residents in this case. Indeed, the State concedes that an individual could not get any sort of benefit whatsoever.
So there you heard the back and forth between Mark Rosenbaum and the Supreme Court and Justice Scalia, in part, on this right to travel and where it comes from. And so this is ultimately what the Supreme Court then held. The Supreme Court held that, quote, the right to travel embraces three different components: the right to enter and leave another state, the right to be treated as a welcome visitor while temporarily present in another state, and for those travelers who elect to become permanent residents, the right to be treated like other residents of that state. For the purposes of this case, we need not identify the source of the right to travel in the text of the Constitution. The right of free ingress and regress to and from neighboring states, which was expressly mentioned in the Articles of Confederation, may simply have been conceived from the beginning to be a necessary concomitant of the stronger union the Constitution created. So, they didn't want to say exactly textually if it's 5th, 14th Amendment, is it Article 4, or is it just inherent in the very nature of our system of government? But nonetheless, it's, again, reiterated, it's firmly rooted in the Constitution. So now we know that we have this fundamental right to travel, even anonymously in many circumstances, within our country, within our union. The question is, what kind of limits can be put then on the right to travel, and what do we do in national emergencies? As you see on our next slide here, we're looking at limits now in national emergencies. So this will take us back to the Cold War. And during the Cold War, Congress passed a law that required a passport for foreign travel by citizens if a state of national emergency has been declared by the president. And so what happened is the president then made a necessary proclamation that there was a national emergency, which then meant no one's allowed to travel without a passport. And the Secretary of State then denied people passports who were applying for passports because of their alleged communistic beliefs and associations and their refusal to file affidavits concerning past or present membership in the Communist Party. So basically, national emergency is declared, and the executive then says, fine, people want passports, you need to sign an affidavit saying that you've never been a member of the Communist Party and you're not a present member of the Communist Party. And even with that, we're not going to give people passports if they're going to be traveling, to communist countries or engaged in communistic behavior, right? To basically narrow who can get a passport. Well, some passports were then denied and people were unable to travel abroad as a result. And so two people filed suit. And the plaintiffs were plaintiffs Kent and plaintiff Briel. And so the case, as you see here on the next slide, is Kent versus Dulles. It goes up to the U.S. Supreme Court in 1958. It's reported at 357 U.S. 116. And here are the basic facts about one of the plaintiffs, Plaintiff Kent. Rockwell Kent wanted to go visit England, and he wanted to attend a meeting of this organization that was called the World Council of Peace. And he wanted to go to England and then go on to Helsinki to go to this World Council of Peace meeting. The director of the passport office tells Kent that he's not going to get a passport because he's a communist with a prolonged adherence to the Communist Party line and the communist behavior. And he was told that he had to submit an affidavit as to whether he had ever been a Communist Party member. Well, he refused. Remember, this is, the Cold War continuing in the 1950s, McCarthyism and all that. So he refused, and he sued for deck relief in federal court that this law was unconstitutional as fundamentally an abridgment of his right to travel. So now we're going to listen to a few minutes of the very heated oral argument on what was the constitutional basis, where is it rooted in the Constitution. So let's listen to this because it's a very spirited debate between the justices and the advocate representing Rockwell Kent.
I don't deny the absence, I don't deny the availability of a constitutional right, but where do you get it from the First Amendment? What part of the First Amendment?
Let me tell you, Your Honor, that I get it in two ways. First, because these people, because they have exercised the right of petition, the right of making speeches.
Well, that's the first time you've used the word the right to petition.
Well, I should have that. The right of assembly.
What kind of right of petition is urged here?
Well, they have addressed themselves to the President
I'm
of the
not saying
United
you may not have a right of petition, but in order to invalidate something on some constitutional ground, we must refer to a provision of the Constitution or something that is inevitably drawn from the whole provision.
Of course.
Now, which part of it? We just announce here every time a question of constitutional law comes up here, just First Amendment.
No, of course, I would not make any such broad statement, Your Honor.
Well, which provision of the First Amendment is it? Is it freedom of speech, establishment of religion?
It is freedom of speech.
Well,
it is freedom of assembly. If Your
Honor,
Honor,
one person going by himself.
Well, no. Let me come back first.
I just want some explicitness.
Yes, I think I must be explicit.
Undo what either branch of the government does.
I would make 2 points, Your Honor. The first is that in denying the liberty of movement to the petitioners.
Now, where does that come from? Does that come from the First Amendment?
I think it probably is simply a liberty within the meaning of the Fifth Amendment. Government concedes that.
All I'm suggesting is that you give me the basis on which you ask me to declare action of Congress or the President or its subordinates unconstitutional.
I'm coming to that, Your Honor. No, it is certainly not. I am suggesting to Your Honors that when Mr. Kent is denied the right to travel because he has petitioned the Attorney General, or because he has made a speech, or because he has taken a public position, or when Dr. Briel is denied this right to travel because he, Dr. Briel, wrote an article for a magazine called Social Work Today, which the Attorney General disapproves of, that this is a restraint upon Dr. Briel and Mr. Kent in the First Amendment activities which they exercised in the past.
But I understood you that the main ground, and almost the major premise of your argument, is that here is an unfair limitation upon the right of motion, the right to travel. Now, does that come from the First Amendment?
I think it comes from the First Amendment, and I think it comes from the Fifth Amendment.
Well, it may come from the Fifth, but does it come from the First?
Well, I think Your Honor is really saying, is liberty of movement the First Amendment right?
That's what I'm asking.
I would say that liberty of movement is a Fifth Amendment right, and that the Fifth Amendment right cannot be taken away from the petitioners because they have exercised First Amendment rights in the past. That is really my point.
Well, so you heard that. It was a spirited debate. It was, he was pushed hard, the lawyer. And as a side note, I think one of the points to make there is listening to that is he was pushed hard to answer the question, and he wasn't really being given a proper, fair chance to really answer the question. And at some point, he kind of politely put his foot down and demanded the ability to answer the question and present what he was saying. And the court listened to him. And I think it's a good example, actually, of effective advocacy, similar to the stuff that in all the advocacy CLE programs you can get, we've done. That I've done within the same platform you're on, you can listen to those types of lessons. So in a little sidebar, I think that was a good example of that. But here now, let's look on our next slide at the Kent versus Dulles case in terms of what the court held. Throughout most of our history, until indeed quite recently, a passport, though a great convenience in foreign travel, was not a legal requirement for leaving or entering the U.S. And so this is actually interesting. For me, it was interesting to know this because the world I've grown up in, obviously, one has had to have a passport at all times, all the time. But that wasn't always the case. So this is back in an era where, looking back within their lifetimes, back to the early 20th century at least, there wasn't always a need for a passport. But, in the next bullet point, the right to travel is a part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. And so this brings us to the mooring in the Fifth and 14th Amendment in terms of due process and in terms of liberty, the liberty rights, provisions of the Due Process Clause. So much is conceded by the Solicitor General. In Anglo-Saxon law, the right was emerging at least as early as the Magna Carta. Freedom of movement across frontiers in either direction and inside frontiers as well was a part of our heritage. Travel abroad, like travel within the country, may be necessary for a livelihood. It may be as close to the heart of the individual as the choice of what he eats or wears or reads. Freedom of movement is basic in our scheme of values. Pages 125 to 26. They also went on to say, its crucial function today is control over exit. And as we have seen, the right of exit is a personal right included within the word liberty as used in the Fifth Amendment. If that liberty is to be regulated, it must be pursuant to the lawmaking rules of Congress, functions of Congress. So here on the next slide, we'll see what ultimately they held. And this is a 5-4 decision, and the court simply says that Congress has made no provision in explicit terms to engage in this kind of restriction of citizens' rights to travel. And so therefore, the use of sort of restricting access to passports for this reason is not appropriate, it's not constitutional, it's not lawful. And so the point being that passports may be allowed as a prerequisite to travel, but limits on them by rules that trip the Constitution are not okay. And so the passports had to issue. Now, remember, this was 5-4. So 4 said, no, those people should not be allowed to get their passports. And what they said was that the national emergency proclamation had been made by President Truman for the Korean War. It was still intact. And so technically there's no peace. This is 1952 when this case is going up. The national emergency is in effect. We are at the risk of, quote, world conquest by communist imperialism is the goal of the forces of aggression that have been loosed upon the world, and that the increasing menace of the forces of communist aggression require that the national defense of the U.S. be strengthened as speedily as possible. And all that being in effect meant, yeah, we should be able to restrict people who are communists from going to sort of engage in communistic type behavior abroad or go to these peace seminars and the like. So anyway, but it was the dissent, they lost. Now, one of the questions, though, is that what about the Kawamatsu case? And so on our next slide, you see the title is But See Kawamatsu? Because if we go back to Kawamatsu, of course, necessarily, we all know what happened in Kawamatsu. And if you don't remember, basically, after Pearl Harbor, President Roosevelt issues an executive order telling the U.S. War Department that he can create military areas within the U.S. from which certain Americans can be taken and placed in base concentration camps. And so the Western Defense Command subsequently ordered all people of Japanese ancestry, aliens or not, citizens included, had to go to these concentration internment camps. And it went up to the U.S. Supreme Court, and the U.S. Supreme Court held that the need to protect the nation from espionage outweighed the rights of Japanese Americans to their liberty and freedom. And thus, among a whole bunch of rights that were abridged, was the right to travel also. Now, there was a dissent in Kawamatsu that said, this falls into the ugly abyss of racism, the abhorrent and despicable treatment of minority groups by the dictatorial tyrannies which this nation is now pledged to destroy. So, that was the underlying case of Kawamatsu. And so how did Kent, of course, deal with Kawamatsu? Because Kawamatsu said in a time of emergency, not only can we restrict the right to travel, we can imprison people because of their race, and it was okay with it. So Kent had to distinguish Kawamatsu, obviously. And so what Kent did was basically not overrule Kawamatsu, but just distinguish it. And it said that we allow the government in time of war to exclude citizens from their homes and restrict their freedom of movement only on a showing of the gravest imminent danger to the public safety. And so basically it said, this declaration of war by Truman about the Korean War going off on Korea, we're now a few years later, these people want to go to Helsinki, not the same emergency as the Japanese attacking Pearl Harbor and then what we did there. Now, it was just their way of rationalizing and justifying it, obviously, but they weren't able to apparently get a majority to overrule it. They just narrowed it to joint action in a time of actual war. And so That then is how Karamatsu remained on the books, at least at that point in time, as still being good law for that kind of a national emergency where the right to travel could be abridged in the most fundamental of ways. So this raises the question of, what if I want to go to Cuba? And so on our next slide, we're going to look at, you see down at the bottom there, our case is in the footer for you this time. The case is Zemel versus Rusk, 381 U.S. 1, 1965. And so this is also a 1960s case that goes up to the U.S. Supreme Court. And basically, here are the facts. The plaintiff wanted to get a passport to travel to Cuba. Because he wanted to go to Cuba, the passport office denied his passport. So the case goes up to the Supreme Court of the United States, which now has to consider the Passport Act of 1926. And under that act, the Secretary of State can grant and issue passports under the rules that the President designates. And the history, at least, that the case recounts, which is fascinating if you want to, as a sidebar, go read it, shows that there have been all sorts of periods in time in American history where, due to serious world events going on, passports were denied. So there's a Belgian famine in 1915, so passports were denied to go there. No Soviet Union travel until 1926 because of the Russian Revolution. None to Ethiopia in 1935 when war broke out there. Europe during World War II and the like. So in any event, that based on that, they, under the Passport Act, the Secretary said, nope, you're not getting a passport to go to Cuba. And so the question then that was raised by the Zemel case is, did the denial violate his constitutional right to travel? And here's the rule of law in this decision. The fact that a liberty cannot be inhibited without due process of law does not mean that it can under no circumstances be inhibited. Requirements of due process are a function not only of the extent of the government restriction imposed, but also of the extent of the necessity for that restriction. And so what they held 6-3 is that Cuba was near the U.S., controlled by a communist government. It had been arresting U.S. citizens, and the executive simply had to have the right to decide who gets to travel there or not in order to protect the United States and the United States' interests. And so the right to travel in that circumstance fell to this national emergency and situation, such as in fires, floods, pestilence, and the like. Now, there was a dissent in this case that said the Fifth Amendment freedom of movement has a peripheral right to the First Amendment and right to associate and assembly, and there should be no limit such that people in peacetime, they can go to Cuba if they want. But it was a dissent, and so that is why the U.S. Supreme Court affirmed the right of the U.S. government to deny anyone the right to travel to Cuba under certain circumstances, which is why to this day you can't go to LAX and jump on a plane to Cuba. Now let's talk, speaking of jumping on a plane to Cuba, about jumping on a plane to Europe, for example, and we're going to talk about passports next. And so you see here we're going to look at, there's a good old picture of our U.S. Passport, some of the rules that sit around passports and the different issues that come up with passports. The first one on our next slide you see is who can get them? Passports. Well, it's got to be a U.S. citizen by birth or naturalization, and this comes from the U.S. Code. It's not a constitutional requirement, it's just from the U.S. Code. 22 U.S.C. Section 212. No passport shall be granted or issued or verified to any other persons other than those owing allegiance, whether citizens or not, to the U.S. Now, there are exceptions to citizens by birth or naturalization being able to get them, and this is in 212B. If you're convicted of traveling in international or interstate commerce for purposes of illicit sex conduct, then a passport can be denied and even revoked if it's been previously issued. Convicted sex offenders may have unique passport identifiers on them also. And of course, there's an oath requirement to get a passport. You have to sign off in this attestation that you've never been convicted of federal or state drug offense or convicted of statutory sex tourism crime. You're not the subject of an outstanding federal, state, local warrant of arrest for a felony, a criminal court order forbidding my departure from the U.S., or a subpoena received from the grand jury. And that's just the oath requirement on the form that people have to fill out. Let's go to the next slide and talk about delays and proof issues that come up when there are delays in getting the passport, where you see litigation resulting, and this is sort of part of our passport litigation module. Castellano versus Rice, coming out of Texas, had a whole bunch of people who said, look, we're U.S. citizens, we want our passports, we're filling out our forms, but we're being denied because we're all midwife birthed in Texas. And the government was saying that, midwife home births in Texas, there weren't proper documentations, so we're not giving you passports because we're not sure you're really citizens. And they were denied passports. So it turned into a class action suit for violating this right to travel. And once it was litigated, ultimately it resulted in a class settlement with fee waivers and policy changes such that midwife birth people don't get subjected to undue and unfair and inappropriate scrutiny in terms of where they were born. Now, Section 1053 of Title 22 also provides a procedure to prove the birthplace for a passport. And so here we have a litigation going the other way, on the other side of the coin, and this is coming out of Florida in 2012, Beltran versus Rivera. And basically, plaintiff secured a delayed birth certificate from Texas 40 years after he was born on affidavits. And what that basically means is, I don't have a birth certificate, but I was born in Texas. Here's affidavits. My brother, my dad, my aunt, great aunt, whatever, they all swear I was born. You take those affidavits down, and there's a state procedure to get this delayed birth certificate issued. He gets it. He then uses it to go get a passport. But passport office, don't know how, but somehow figures out, there's a Mexican birth certificate was issued for you also. So they deny it, saying this one doesn't make any sense, and they delay ruling on it and ultimately deny it. So he files suit saying, no, I was born here, I'm a citizen. Federal bench trial, not a jury trial, right? And ultimately he lost because the court concluded on this more likely than not standard that he didn't prove that it was more likely than not that he was born in the U.S. and that contemporaneous Mexican birth certificate trumped the statements of the family. Now, interestingly, here is another law when it comes to passports. It's illegal not to use them in certain circumstances. It is unlawful for a citizen of the U.S., unless exempted, to enter or depart or attempt to enter or depart the U.S. without a valid passport. So if you just stop there and pause for a second, wow. I mean, quite literally, it's a crime. It's illegal for us to leave without one or even try to leave without one. Didn't find any prosecutions under the statute. That's the good news. They probably just turn you away at the airport when you don't have your passport. Now, there are exceptions for cruise ships, armed forces entering from contiguous areas and territorial lands, like coming back and forth across Mexico, for example. Driver's license is okay in circumstances. But still, it's powerful and important to know that as a curious lawyer, take that passport. What happens when you lose them on our next slide? Well, criminally invested and convicted can be ordered to surrender their passports, and they can remain in court custody until the conclusion of the case. And if you renounce your citizenship, as in the case of Hewer versus U.S., you can find that you renounce your citizenship and passport, you may never get it back. And so this person renounces citizenship at Venezuela. It's a certified official document. Then later changes his mind and he sues to say, I want to unrenounce my renouncement or de-renounce my renouncement, whatever the word is. Government's not interested in hearing that. Goes to court and they said, nope, there's a 5-year statute of limitations anyway. And so the privilege of a passport is now permanently lost. So the point being there, don't renounce your citizenship. Now, let's shift briefly to post-9/11 world. You see on our next slide here. There's a trusty picture of an airplane taking off from Heathrow Airport. I actually took that photo myself, sitting on the roof of a building. They're one of the terminals where you can have a meal and watch planes take off and land. It's a fascinating place, but it gets you thinking about post-9/11 rules. And that brings us to airport and surveillance restrictions. We're going to talk really briefly about real ID travel, screening and body scanners, and watch lists and the like. So, the next slide, airport rules on right to travel. The Real ID Act says, as of 2025 at least, we have to have a Real ID card, which is the elevated form of state ID, which has higher background proof documents to get. So if you have to go down and get it, you've got to take your social security card and do all these other things that are not required by state law otherwise, but states have been forced to up their law, their ante in terms of issuing driver's licenses to meet federal law. Is it constitutional, though, for the feds to do that to the states? It's a fascinating question. There's probably going to be litigation on it. It hasn't been adjudicated yet, but if you go back to the 10th Amendment, there's a 10th Amendment argument under the Prince versus United States case that the federal government cannot do this because the federal government is commanding the state's executive powers basically by compelling them to execute federal laws regarding driver's licenses and ID criteria, which is a state-reserved state right. And because that remains a function of the states, the minimum issuance and verification requirements are effectively an act of commandeering by Congress. That's at least the argument that may well be made, like the Brady Handgun Act background check case that was struck down on 10th Amendment grounds in 1997. So stay tuned for litigation. The next slide is going to take us to airport screenings and watch lists. And here we have the question about airport searches, where we walk in and we are subjected to a package search, body search for the sole purpose of making sure there's no weapons or explosives. Everyone is done to everyone. It's not because of a reasonable suspicion or probable cause as to any one person. And what the standard rule is, and this is a Third Circuit case, it's just a prototypical one, but it's the same across the nation, is that suspicionless checkpoint searches are completely permissible under the Fourth Amendment because of the gravity of public concerns served by them versus what's going on with airports and safety and security. And so there's not even a need for a reasonable suspicion as to one person when you're assuring that no one has weapons and explosives at airports. The same is true even for random secondary searches of the body for materials, and that's constitutional. And you see here a Ninth Circuit case of U.S. versus Marquez that allowed random second TSA searches with the wand technology, those wands that they wave on us at the airport. When sometimes, you go through the first one, and then they're like, come over here, and then they wave a wand over you or feel you or whatever. Those were deemed completely constitutional too. And there, in that case, for Mr. Marquez, it didn't work well because there was a random secondary search that was done, and it was actually factually random, it turned out. But the wand technology showed something odd, and then they did a further physical search, and they found a whole bunch of cocaine bricks. He tried to get it suppressed as being, the fruit of a poisonous tree on an unlawful search. Denied. He went to jail for cocaine. So the point is that an airport screening search is reasonable if it's no more extensive or intensive than necessary given the technology to look for weapons or explosives. But important point there, technology can be used, confined in good faith for that purpose, and you can avoid the search completely by just electing not to fly. That's the rule. Let's talk about some limits on this, though. And on our next slide, we're going to talk about a TSA conversation that happened between a guy named George and a TSA officer. So George is 21, he's in Philly, he's going to California to go to his last year at college out here at Pomona College. And he had some Arabic flashcards and a book critical of U.S. foreign policy in his possession. Turned out he was a double major in physics and Middle Eastern studies. But nonetheless, they see all these flashcards in Arabic, so TSA stops him. And so here's the transcript between him and the TSA. TSA, you know who did 9/11? George, Osama bin Laden. TSA, do you know what language he spoke? George, Arabic. Do you see why these cards are suspicious? So that's how the conversation went down. George was not amused because the police were called, the FBI was called, he was detained for 5 hours, at which point they finally released him when they realized, I guess he's a student, he's not really a terrorist carrying around flashcards with the word, like cheese on it, and then one flashcard had the word bomb on it or whatever. They realized, silly. But nonetheless, he files suit. And so the question then is, was this okay what the TSA did? Well, here on the next slide, the holding, you see, yeah, it was fine. Basically what the court said is, all those words in Arabic English flashcards were confounding and serious and enough to make the TSA people concerned, so they had the right to stop him. They had a justifiable suspicion that allowed further investigation, but the court said this case, the fact pattern really reaches the outer limits. We caution, however, that the detention at the hands of the TSA officials is at the outer boundary of the Fourth Amendment. It's important to note that harboring views that appear to be hostile to the U.S. government or its foreign policy, such as he had a book that was negative about American foreign policy in the war, is most assuredly not by itself grounds to detain him or search him even, given the U.S. Supreme Court precedent in Terry. But at the same time, it's simply not reasonable to require TSA officials to turn a blind eye to someone trying to board an airplane carrying Arabic English flashcards with words such as bomb or kill on them. And so the result is that his claims were dismissed and the TSA was exonerated, but I think it's clear that case hits at the outer limit of what the TSA can do. Now let's shift really quick to embassies. Are they U.S. soil? Are they a safe zone? Rights abroad. There's a picture of our U.S. embassy in Casablanca. Let's find out. On our next slide, is a U.S. embassy abroad U.S. soil? The answer is no. It is not American soil. It's foreign soil. But they are by international law given unique treatment. So the Vienna Convention, International Convention, basically provides that the premises are inviolable. And so the home country cannot simply enter them unless the consent is given by the U.S. embassy. So the people in Casablanca, the local police or whatever, cannot go in unless the ambassador or whoever's in charge of the embassy gives them permission. So it's treated under international law as basically being an immune space, but even if it's not sovereignty, as in i.e. like U.S. soil, it does come awfully close given the immunity that's there. So on our next slide, we're going to have a fun little viewing here of a minute of the film The Saint, the Val Kilmer, Elizabeth Shue film. Personally think it's kind of a cool, fun movie. If you haven't seen it, I highly recommend it, but watch this minute of film.
off from the gate. Back off. I said back off. Stand back from the gate.
There you go. I'm an American. I'm American. Let me in the embassy, as she screams, and the Marines save her at the last second as she's rushing across, the streets of Moscow to get to the American embassy to be safe. So the question that we're asking, as you see here, is on our next slide, is it safe? How safe is it? Does this happen? Can that happen? Well, it turns out it can be. If you enter an American embassy, you at that point can't be yanked out by the local police. So yeah, Elizabeth Shue made it safely into the embassy, and although she's not on U.S. soil, she's in a place that's immune from entry by the local Russian police, or in that case, the warlords, but the police, importantly, in the state. And so, what the embassies ultimately have to balance human rights issues with their treaty obligations in terms of what they do when they give refuge to people who are wanted for crimes. And so what's also very clear is, you go commit some local theft in Russia, rob a bank or something, and then you go to the embassy. They're not going to keep you in the embassy forever and just let you, they're going to hand you back to the Russians and you're going to go to jail for robbing the Russian bank or whatnot. This is the balance they have to do between law and order and propriety. But one famous example, of course, is the Hungarian Catholic Cardinal Menzensky. He spent 15 years under the protection of the U.S. Embassy in Budapest, literally living in that building you see there for 15 years because the U.S. refused to hand him over to Budapest because of their genuine show trials against him. So what are your rights abroad on the next slide? In other words, let's say you do get arrested in Russia because you rob a bank or you do something. Don't rob a bank anywhere, especially not Russia, I would suspect. But will the embassy get you out of the local jail if you're arrested? The answer, emphatically, no. That quote there is from the U.S. Embassy's website, the usembassy.gov website. We cannot get U.S. citizens out of jail. We cannot provide legal advice. We cannot serve as interpreters. We cannot pay legal, medical, or other fees. In other words, get arrested in a foreign jail, you're on your own. You can call the embassy and hope for the best, but there's no legal obligation under the law to protect you or do anything to get you out. That's where you are. The advice then, when we travel abroad, travel carefully. That is our program today. Bon voyage on your travels. And on our last slide here, I'm going to summarize for you some of the conclusions that we've come to in today's program as we've traversed this right to travel on this fun little Curious Lawyer exercise to learn about it. Number one, the right to travel is a fundamental constitutional right, and it really does come from all of those Supreme Court cases we saw. It comes from the Due Process Clause and from the Article 4 Privileges and Immunities language about ingress and egress from states. And so it genuinely is a fundamental right. It's been held repeatedly as such. That said, it doesn't actually say anywhere like the right to travel. But nonetheless, it's clearly a fundamental right given all the laws and case law we've seen and the court's incantation and discussion of the right. But it is subject to limits in emergencies for genuine national security related concerns, and we saw the cases on that. So what we also saw is that state laws, and so this now takes us out of the kind of international component, but state laws that seek to make interstate travel harder, those will fall regularly. We saw that in the Edwards case and the Sines case. Nonetheless, the right is sufficiently deeply rooted that even our right to move around anonymously, just as we go about our business, is protected. And that was the Colender case. Now, when we start talking about international travel, it can be limited by federal emergencies and proclamations related to national security interests. But that said, there are limits. So in other words, the executive doesn't just get to, by fiat, define what those national security interests are, and then just that ends the inquiry. Courts will look at this. And so what we saw is that general pro-communistic leanings, that's not enough to justify executive limits on international travel. That was the Kent case. But very specific executive concerns, for example, about Cuba, national security, the danger that could come to Americans going there, that's enough to say, yeah, we're going to limit international travel to Cuba. And that was the Zemel case that went to the U.S. Supreme Court. Airports, we looked at too. Airport searches at the point of departure are permitted with incredible flexibility within our Fourth Amendment. And this is a sort of a great example, an area of something that we all do day in, day out without even thinking about it. But it is a very different Fourth Amendment rule to the rule that applies as we're walking down the street, you're walking into the bar, you're driving your car. It's just a different rule. It's a much broader standard in terms of the retreat of our Fourth Amendment rights and the grant to the government. And we don't really think about it day to day because we recognize sort of the way the court has come down on that kind of comports with, I think, the general perception of the importance of making sure there's no bombs and weapons on planes. And so as a result, random searches for explosives and weapons by technology and the ever-advancing technology being used in airports is all totally fine without any need for any particularized suspicion on anyone. Now, deeper detentions to investigate people are also acceptable once a TSA person's ideas or concerns are tripped in that realm. And even literature that may be suspicious may provoke a hold for some amount of time. But we saw in that case the court troubled ultimately by the fact that it hit the outer limit. I mean, they held him for 5 hours, and that was kind of the outer limit when they realized the guy he's not a threat, he's not doing anything, you got to let go at that point. But nonetheless, yeah, you may be subjected to a 10, 15, 20-minute, hour-long delay if you're carrying the wrong stuff on an airplane. So in that sense, bon voyage, but be careful. Finally, when you're on that trip abroad, remember, U.S. embassies are actually not U.S. soil. That's just not true, even though conventionally people think they are. They do have international law-based immunity, so in that sense it's good, but travel safe so you don't need to run like Elizabeth Shue into the arms of a Marine in an embassy. Thank you, and as ever, if you have questions, please email me.